Recording started. Thank you.
Thank you very much. Members online, we've tried it with the recording in the chamber. This is a suggestion from Teresa, not me. If you'd like to put your volume up at home, that might be appreciated. If that doesn't work, we've got to switch your cameras off. See how I just starting? Councillor McWhinney?
Sorry, I just want to say if you put volume up really loud, you get deafened when somebody tries to speak online.
Okay, I'll switch my camera off and see if that helps. That'll be a delight for you. No problem. Okay, we'll move on. So we will now hear from Area Manager on behalf of Conrad Ritchie. So you have 10 minutes to read out Mr. Ritchie's representation, which should focus on the views already expressed in writing by Mr. Ritchie. Please begin when you are ready.
Thank you, Chair. At the outset, I want to be clear, I am not here to oppose this development. I am here because a series of early procedural choices were made under time pressure, choices taken to keep the process moving, and those choices may now be narrowing the environmental assessment in ways that are only becoming visible at this stage. Point 1, RSPB not invited at scoping. One of the earliest choices was not to invite the RSPB to participate at scoping, despite the landfall being adjacent to Loch of Strathbay. That decision prevented their expertise from shaping the scope itself, which is when influence matters most. Question 1, was the best available ecological expertise used at the point when the scope was fixed? Point 2, RSPB awareness came later. The RSPB only became aware of the project later via the public, not through the scoping consultation. By that point, the scope was already adopted and their concerns could not shape what the EIAR was required to assess. Question 2, are you comfortable that important environmental concerns only emerged after the scope was fixed? Point 3, Nature Scot advice not awaited. A similar issue arises with Nature Scot. Nature Scot required a short additional period to provide their advice. The Council chose not to wait and adopted the scoping opinion without it. That was a lawful choice, but it had consequences. Question 3, was speed prioritised over completeness at the scoping stage, and is that still appropriate now? Point 4, time pressure explicitly cited. Time pressure is repeatedly referenced in correspondence, including a desire not to delay matters by a few weeks. Short delay then may have allowed full expert input to shape the scope. Instead, those gaps now sit with members at determination. Question 4, is a short delay earlier preferable to carrying unresolved uncertainty forward now? Point 5, scope fixed without full expert input. Taken together, these early decisions meant the scope was fixed without full range of external expert input for a highly sensitive location. That is not a criticism of individuals, it is simply how the process operates. Question 5, does the location warrant proceeding without certainty that all relevant expertise shape the scope? Point 6, risk carried forward to members. Practical effect of those early choices is that questions about scope and completeness now sit with members. Officers have indicated that matters can be addressed later, but that shifts risk from process certainty onto member judgment. Question 6, are members comfortable inheriting that uncertainty at determination? Point 7, scoping choice and consequence. Scoping was entered into voluntarily in this case. Once that happened, Regulation 17 applied. Scoping is not an informal exercise, it fixes the minimum environmental matters that must be assessed. Once the scope is set, everything downstream follows from it. Question 7, are you satisfied that scoping was carried out rigorously and lawfully, given its role in fixing what the environmental assessment must examine? Point 8, what members are being asked to do. I am asking for competence in the environmental information you are being asked to rely on. Before determination proceeds, I am asking members to request written confirmation of what officers consider the adopted scope to be and whether Nature Scot's input forms part of it. Confirmation of whether the EIAR was checked against that scope and fully corresponds to it. Confirmation of whether Nature Scot's advice was treated as a requirement of the scope when the EIAR was prepared. Confirmation from the developer of what they understood the adopted scope to be and whether the EIAR was prepared on that basis. A short written reconciliation showing whether those understandings align. Question 8, before determination proceeds, would it not be safer to pause briefly, close that gap and proceed with certainty? Closing reflection. Those early choices explain how we arrived here. The question now is not blame, it is confidence. If this development is to proceed, it should do so on the basis of the clearest possible environmental record, informed by the best available expertise at the right time. That is why it is reasonable to pause and ensure that what members are being asked to assess genuinely reflects the scope that should have been applied. Thank you.
Thank you, Amanda. Councillors, do you have any questions in relation to Mr Ritchie's representation? Councillor Gifford, please.
Yeah, just a kind of a general question. Do the planners or the applicant have anything to say in regard to the comments made?
Thank you. Please just come on.
Yeah, thank you, Chair. Let me just want to pick up on a few points raised there. Hear me. The first one I would say is the RSPB are not a statutory consultee, therefore do not require to be consulted under the regulations at the scoping stage. I should also say as well, scoping is a voluntary exercise, and the scope of an application is actually never truly fixed. It is an opinion offered at a point in time based on the information available. Factors can change between a scope being adopted and an application coming forward. Therefore, the planning authority always have the option under regulation 26 of the same regs to ask for additional information once a formal application has been submitted. In this case, we did provide an initial scope and opinion without Nature Scott advice at the time. However, this was provided to the applicant at a later date, and it was evident this had been taken into account as when the application was accepted by us. Past the validation stage, we didn't receive any additional requests for information, and we also didn't receive any objections from any of the noted consultees. Other points. I think that's about it, Chair. Yeah, the scoping is an advisory, and obviously things can change, and the planning service always have the obligation under regulation 26 to ask for more information if it's not completely satisfied before it proceeds to determination.
Thank you, Stuart. Councillor Gifford.
Yeah, thanks, Chair. That's a very comprehensive answer. Thank you.
Thank you. See no further indications. Obviously, I'm unable to confirm with Mr Ritchie if he's satisfied that he has had the opportunity to put his views forward this evening. However, I believe we have offered the best alternative to Mr Ritchie this evening, given his unavailability. Thank you. We will now hear from Susan Emerson. Emerson, you'll have 10 minutes. You should focus your comments on your views expressed in writing already. Put your mic on and just begin when you're ready, please.
The red light's on, does that mean I'm on?
That's you, you're not on.
Can everyone hear me okay? First of all, thank you for inviting me here to speak today. It's much appreciated. I'm here because I believe the speed was prioritised over due process at the scoping stage, and that choice has had consequences. The scope was adopted before full expert advice had been incorporated. An addendum is now presented as part of the scope, although it was not formally adopted as binding scope. Key consultees, and I take the point you made earlier, Stuart, the RSPB are non-statutory consultees, but they were not involved at the scoping stage, so they weren't invited despite being right next to Lochistrar Beck. No documented scope to EIR reconciliation was carried out in validation. Completeness has been assured without a single document confirming how the EIR corresponds to the scope now, said to apply. Despite extensive correspondence, FOI requests, MSP correspondence and repeated attempts at clarification, it remains unclear what the legally binding scope actually is. Which brings me to the fundamental question, what is the binding scope of this assessment, and does the EIR before you correspond to it? If there is a difference between what the officers now say constitutes scope and what the developer treated as binding scope when preparing the EIR, then clarity's been lost. As Conrad had picked up in his statement, that transfers the risk forward determination into the members. That's the issue I ask you to consider. The scoping opinion was adopted on the 23rd of August 2024, before Nature Scott's advice had been received. Rather than waiting or seeking a short extension, which the regulations allow, the Council adopted the scope and later forwarded Nature Scott's advice as an addendum. Regulation 17 provides for one adopted scoping opinion. An addendum is not a formally adopted scope. The effect of that decision is that Nature Scott's requirements were not incorporated into the binding scope. Point it was fixed. In correspondence, the Council confirmed that the option was available to seek an extension to the deadline for issuing the scoping opinion until the Nature Scott response was received, and that the regulations allow this period to be extended by agreement between the developer and the planning authority. The mechanism existed, it was acknowledged, but it was not used. A short delay at that stage would have ensured expert advice formed part of the adopted scope. In EIR Chapter 2, the adopted scoping opinion and the addendum are presented together. However, presentation is not adoption. There is only one formally adopted scoping opinion dated the 23rd of August 2024. The key question therefore becomes whether the developer prepared the EIR on the basis of that original adopted scope or on the basis of the adopted scope plus the addendum. The EIR does not transparently demonstrate that it was prepared on that combined basis. The Council confirmed that RSPB was not consulted at the scoping stage on the basis that ornithological expertise was already covered by Nature Scott and the Council's Natural Environment team. However, RSPB later confirmed they were not aware of the project until October 2025. It was myself that notified RSPB. I do have the confirmation here that they had no idea. I did suggest then that they contact the Council and that they make a representation of sorts. When informed, they did raise these issues, including seasonal construction restrictions at Mock-Up Strathbell. And those restrictions had not been previously identified by the Council's Natural Environment team or Nature Scott. Therefore, excluding the RSPB at the stage when scope was fixed limited early expert input at an internationally recognised site. The Council confirmed there is no provision within the regulations that explicitly requires the planning authority to check that the EIR aligns with the scoping opinion at the outset. The comparison between the scope and EIR is deferred to ongoing assessment. Yet in correspondence to the MSP, Carnarvon, the Council stated it was satisfied that the approach taken ensured that all matters raised by the consultees were included in the EIR. Completeness has therefore been assured without a single documented scope to EIR reconciliation and validation. Each of these decisions may appear procedural in isolation, not waiting for Nature Scott, not seeking an extension, treating advice as an addendum, not consulting RSPB, not conducting a documented scope to EIR check at validation. Individually, they may seem minor, Collectively, we mean that the scope was fixed without full expert input, and the EIR has not been transparently reconciled against the scope now said to apply. That creates uncertainty about what governed the assessment. I'm not asking you to reject the development, but I am asking you to ensure clarity before determination. The full structural remedy, the preferred one, would be to readopt the scoping opinion, incorporating full expert advice, require the EIR to reflect that binding scope, and conduct a formal scope to EIR reconciliation. However, that may not be practical time-wise. So the alternative could be that the council provide written clarification of what the authors consider the adopted binding scope to be, and confirm in writing whether the EIR corresponds to that scope, and identify any gaps before determination. A short administrative pause is an inconvenience, but proceeding without clarity carries far greater consequences. The Loch of Strathbeg is an internationally recognised site and it deserves certainty. So I return to the fundamental question, what is the binding scope of this assessment, and does the EIR before you correspond to it? I ask you to pause briefly, clarify that question, and proceed with confidence rather than ambiguity.
Thank you. Councillors, do you have any questions for Ms. Ensign, please? I see no indications. Councillor Smith?
Chair, if nobody else is going to ask, I'll just, not a question, but maybe just the planners comment on what we've just heard.
Sure, please.
John. Yeah, I would just again kind of reiterate a few points there. Ultimately, we are satisfied with the process that's been undertaken to date. Say that the regulations will require the plan authority to consult bodies before an opinion is offered. We don't have to wait for their response set out in the regulations. We also have the opportunity to provide more than one opinion under Regulation 1712 of the regulations. I think so notwithstanding the perceived effectiveness of the scoping process, it is ultimately, it's an opinion, it's in the title of the document being offered. It's an opinion being offered at a point in time, and we always have the opportunity to ask more information when the formal application is presented. I wouldn't agree with the term of a binding scope, because I said before, this can be a flexible process. Things can change, things can be scoped out, things can be scoped in, but the important thing is when the application is submitted to us, that all consultees we invite to input to that process are satisfied, which is the case for this application. So I would say, yeah, we're satisfied with the process and there's no need to delay or pause for this submission.
Am I able to respond to that, Chair?
So, sorry.
Okay.
Thank you. Being no further indications, Ms. Ellison, are you satisfied that you will have the opportunity to put your views forward this evening?
I am satisfied. I'm not satisfied. I wasn't allowed to I'm a debater to Mr. Newland's so that's fine. I'll put that in writing separately.
Okay, thank you. Thank you. Councillors, I am now required to confirm that you have received all the information you require. I will take this opportunity to remind you that you are permitted to recall any speakers to seek clarification should you so wish. I see no indications. Thank you everyone for attending. As advised earlier, a planning report will be circulated to Buchan Area Committee along with a note of the predetermination hearing. The Buchan Area Committee will then forward their views to Infrastructure Services Committee for its consideration when determining the planning application. I will now close the hearing. Can I ask that the live streaming and recording be stopped, please?